That's all.
I am the petitioner in this case.
Have you informed the other
I
side?
have informed the other side.
He has no objection.
He said he has not been.
Then counsel for the petitioner seeks time. It is submitted that it is already informed to the counsel for the respondent and he has no objection. This matter after 2 weeks.
Not interim order may be indicated.
The order earlier granted is extended.
13 loads, I'm sorry, 13 loads. I appear.
Earlier granted is extended.
Obliged.
Page number 6, serial number 22 to
20.1.
20.
20 and 20.1, but these are petitions filed by lawyers, Lord, who are in occupation of the property. Property has been sold, Lord, we did not come in the way of Lord, property being sold. We are all tenants there. My Lord gives 1 week. My Lord, we will talk to the auction purchaser to see whether, my Lord, they can continue us. We are all lawyers, my Lord, who have established our offices. We did not challenge, my Lord, this sale.
Lawyers are people apart. Not law doesn't apply to them.
Apart, my Lord, only saying, my Lord, since they have established their offices there, my Lord. Only to talk to the new buyer, my Lord, we are not coming.
A week.
Yes, my Lord, 1 week.
This is matter next week, no further adjournments.
Yes.
Serial number 21, my lords. I appear for petitioner, my lords. Senior is not well, my lords, since yesterday afternoon. So, my lords, a week's accommodation, my lords, any date in the next.
My lords, respondent, they have not complied to the interim order which was passed in 2024, my lords. Kindly dismiss this petition, my lords. It's
In the
interim
next
order to
week, my
pay
lords,
5 lakhs has not been complied since the
What are
year
you doing from
2024.
2024 without even filing
My
moving
lords,
this matter?
we had moved a memo and we filed our wakalat.
So
We wanted
wherever
to
the
make-
petitioner is seeking adjournment, I can understand there is an interim order.
And they have also filed an.
He submitted that the land counsel, the petitioner is unwell. List this matter next week, no further adjournment.
Please.
My
Land
lord,
counsel, the respondent opposes the same. Yes?
my lord, serial number 15, my lord, it is listed on preliminary hearing. I appear for the respond number 2, my lord. Respond number is 2 more. The respond number 2 is no more, my lord. Lost 10 days back, he has expired, my lord. I have to bring the lost on record, my lord.
First
1
of
week
all,
at
we'll see. First of all, we'll see what is the writ petition about, anything survives for consideration or not. If it is, if notice to second respondent is necessary, then the LS can be brought on record. Yes, next.
My lord, serial number 14, I've informed the opposite side. Serial number 14, I've just informed the opposite side. That
They have no objection.
My-
Same, inform to the other side respondent has no objection for adjournment, list after 2 weeks.
please.
My lords, on
Yes.
submission, serial number 10, my lords.
Yes,
My lords, the on record counsel, my lords, this father ceremony, my lords. Now, my lords, the complaint the interim order. My lords, kindly have it in 2 days' time, my lords. You will come and make submissions, my lords.
have you informed the other side? We'll adjourn it when he is there. Yes,
Please.
next.
For order dismissal, serial number 1, Rala Kumar for
Yes.
petitioner.
For the petition.
Yes. Karthikeyan.
Lord, in this matter, yes,
Yes.
as challenge the sale name,
Hmm.
sale certificate wide exhibitor, annexure, oh my lord, annexure N.
Please come to your prayer first. Let's
Yes, my lord.
see. Registered sale certificate.
Yes,
Why should it be done under 226 and before this court? Why not DRT?
hello, my lord, property value even according to the bank, it's
Whatever it is, can't it be raised before the DRT?
without providing any opportunity, the sale has been made, my lord. Only-
Whatever it is, can't that be decided by the DRT? Why are we hearing this?
Because only these are the two aspects, my lord. That's only the two aspects, the market value, what they according to the bank itself is.
No, all this inquiry, whether it is correct or not, it would be it would be easy for the DRT to do all this exercise than the High Court. Because there's so many disputed questions of fact that are involved in
A
this.
very short point, that is the only aspect. That's why I'm before your lordship.
Yes, what is the short point?
My lord, without intimating to the petitioners, the sale has been made secretly. And even according to the bank, my lord, the property value is more than 4 crores. In fact, market value is more than 7 crores. They have sold it for 2 crores 54 lakh
What is
thousand.
the outstanding amount?
Outstanding amount is 2.5 crores, my lord. For that purpose itself, they were.
Is it a first sale? Is it a first sale?
First sale, my lord.
Yes.
I am appearing for statement.
Who has conducted the auction?
Notice has not yet gone to the other side.
And when is this writ petition filed?
I moved
In the month of May 2025. Notice is not even ordered till now.
Twice I have moved.
That's why all the more reason that you should go to the DRT.
My lord, let the point this may be decided, and so that.
Why should we, if really you're interested in getting this matter listed and decided, you wouldn't have waited for these many years, these many months. The present writ petition.
Order for notice, and this one it can be disposed of, my lord. And stuff.
No, all these disputed questions we can't. The writ petition is filed seeking the following prayer. It's a case of the petition that there is illegality in conducting the sale by the respondents. If that is, if the petitioner is aggrieved by by any of the action of the respondents in conducting the sale, and he wants a sale to be set aside, and to set aside the registered sale certificate issued in favor of the auction purchaser, the remedy available to the petitioner is not before this court. When a tribunal is constituted to decide the disputes of this nature, the petitioner this court cannot exercise the jurisdiction under 226, and this is not an exceptional case that the court has to consider this writ petition. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy in accordance with law.
For order, serial number 2, Anish Acharya, for petitioner.
Yes.
I appear for the petitioner. The matter has been settled between the parties, so we are filing a memo seeking withdrawal.
Copy is not received, my lords. Copy is not received.
What do you want? You want to withdraw the writ petition? The memo is filed stating that due to subsequent development and what is the interim order? Is there any interim order?
Yes, my lord. Stay has been granted.
Usual interim order on 18/9/2024, 2,50,000. What is outstanding amount?
Now I call to. Serial number 2. 2 na.
What is the number?
WP number.
It's 25541, my lords.
25541 is 2 only. So, from 2024 till now, you are enjoying an interim order without even complying with it. Now the day has come that you say that what you're saying is not there in the memo, saying that it is settled between the bank and you.
We have received instruction from the client that the matter has been settled.
No, but the memo is not what you have filed. You just say that for personal reason you doesn't want to prosecute the petition.
We'll file a new memo, my lords.
We will not permit this kind of abuse. I want the interim order is granted in the year 2024 till now without even paying anything. The respondents, the petitioner is enjoying the interim order. Today when the matter came up, it is submitted that they want to withdraw the writ petition, stating that the dispute is amicably settled between the parties. However, the memo that is filed before this court is silent. The petitioner shall file an appropriate memo, or else the orders will be passed on merits next week List next matter.
Kindly a short date may be given, my lords.
Huh?
Kindly a short date may be given.
How short it is?
Next week, my lords.
That's what I said.
Yes, my lords.
Serial number 3. Serial number 3.
And for the respondent hearing.
What is this IA number 1 of 25?
IA number 1 of 25 is filed for impleading, please.
That copy is not
Sorry.
served to me,
Not the impleading, it's for vacating stay, please.
What is the writ petition about?
The writ petition is, my lords may kindly see the annexure L.
Let's see the prayer first.
Prayer to set aside the annexure M. To quash the communication letter dated 20th 9th.
What is the communication?
Communication, they are saying that auction is take place, e-auction is take place and property has been action. That is the communication has been informed. Prior to that, my lords may kindly see
No,
annexure.
no, before going to that, your prayer is to quash the communication.
Please, my
Now we
lords.
will quash the communication. What will happen?
Action sale will be goes, my lords.
Auction will go.
Please.
How? Without
Because-
questioning the auction that is done, how can the auction be set aside?
Before, my lords may kindly see. That's why I'm, please, the fact is this, my
There are
lords.
several proceedings before it, isn't it?
Please, my
Are you
lords.
not supposed to question all that? If at all you want to, whether the court will entertain the writ petition or not is a different aspect. A communication received from the bank, if it is set aside, according to you, auction will be set aside.
My lords, prior to that, on 26/9, they have given a letter saying that this is the amount under OTS scheme you required to pay. 17 lakhs 50,000. I have paid 17 lakhs. 50,000 is concerned. I also DD is ready to hand over the bank. Without accepting the same, they proceeded to take an action. Therefore, I am approached this honorable court for the protection. I am clear that whatever the amount shown as OTS proposal is concerned, 17 lakhs 50,000. I have paid the amount to the bank. In spite of, they proceeded to take an action.
Then your relief should be something else, not this to set aside the communication.
Like that is, see, I have to pay amount within honor before 30th 9 2024.
Yes.
In so far as
Without
the
waiting for the same, my lords.
OTS proposal is concerned, I take my lordship to turn page number 46, please. my lord.
40?
46, annexure L.
Yes.
The subject, dispute regarding OTS proposal. I take my lordship to the second para. The outstanding balance loan amount of Shri B.H. Naga Hanumegowda as on the date on 26/8/2024 is rupees 22 lakhs 50,241.
Where do you get that?
The second para, so after subject,
E-auction notice after subject.
as per the direction of the Honorable Court dated 9/8/2020.
Are you referring to page 46?
Page 44, my lords.
46 as per annexure
Ashok
L.
Nagar, that
Papers
is-
annexure L, page
Annexure L,
44.
please.
Yes.
Annexure L.
Yes.
After subject, as per the direction of the Honorable Court dated 9/8/2024, we are offering you OTS proposal to settle the loan account of so and so. And next para, please, my lord. The outstanding balance loan amount of Shri B.H. Naga Hanumegowda as on date 26/8/2024 is rupees 22 lakhs 50,241 rupees. The proposal, this is the outstanding amount, so that we have given a proposal of 17 lakhs 50,241 rupees. They have not paid the amount, they have not accepted this OTS proposal, so that e-action was conducted, and subsequently the action purchaser has deposited the entire consideration
When
amount.
was the auction?
Action was held on 20th
20th 9 2024. my lords.
20/9/2024, please, my lord. On 15/10/2024, the entire,
After conducting the auction, you have given a OTS proposal.
no, before itself.
But how the dates are matching? The 26/8/2024 is the OTS.
OTS, please, my lord. On 29,
Huh?
29, action was conducted. And the
20th
next
9.
month.
29.
Yes, please.
Yes.
29, action was conducted, and subsequently the action purchaser was deposited the entire amount of 1 crore 10 lakhs rupees 50,000 on 15/10/2024 itself, and subsequently we have communicated 15/10/2024. 24, entire action amount of 1 crore 10 lakhs 50,000 was deposited before the
Yes.
bank. And subsequently, we have communicated it to the petitioner under this annexurium.
That's the influence.
Yes, please, ma'am.
That has to be set aside now.
That they wanted to set aside without questioning the e-action proceedings as required under section 17 of the SRPC Act. They come before this honorable court for
The communication is rated
communication is dated 29/20/24, please.
29.
20th 9 2024.
20. 20th 9/2020.
On the same day.
Same day we have communicated. We
Now,
have issued
according
the
to
letter.
him, he has paid 35 lakhs. When is that?
Not the 35 lakhs, please.
Just now he's saying.
No.
My
He has
last may
paid-
kindly see, please, just 1 minute. My last may kindly see annexurium L, page 44.
Yes.
Last paragraph, my lord. We are offering you as an OTS proposal of rupees 17 lakh 50,241 and till 30th 9 2024 to
So,
settle and
so-
close the loan account.
Yes.
Please, my lords.
Show one piece of paper to show that
Please, my lord.
you have paid the amount by 39/2024.
Please, my lords. I have given a reply on 30th 9 2024. Before that,
How can you give a reply on 39 when
no,
they're
my lords,
asking
I
you
have
to-
paid the amount. I have mentioned that.
So where is that?
Please, my lords.
Your bank account will show.
Page 49, my lords. I will produce that, my lords. Page 49.
This is a legal notice.
Please, my lord, I have replied to the notice issued by them. On 20th 9 2024, they have given a letter as against which I replied in response to the assurance made by my client appears to have deposited 10 lakhs by DD number so and so. My lords may kindly see that. I have paid that 10 lakhs.
So
Prior to that, I have paid 7 lakhs and also I am ready with DD of 50,000 rupees.
that court is not concerned with all that. Please show me by 39/2024, you have paid an amount of rupees 17 lakhs.
Please, my lords, I will produce the documents before this
You
court.
should have done it by filing the writ petition, not when the court asks you.
No, my lords,
Court
I
will not
produced.
understand.
It is,
Then let's see that.
it is recorded in the proceedings matters. It is in Kannada version, in the order sheet
Let
of
us
the.
see. Kannada
authority.
version
Please,
also
my
we
lords.
can see. Yes, where is
Please,
that?
please, my lord. Page 40,
Page?
40, my lords.
Where is this?
In the writ petition, it is an order sheet before the authority. In the court only, I have given a DD for the bank.
Point out that page
Please, my
number.
lords. Rupees 10 lakhs, DD number so and so.
Where do you get that?
Page 40 of the writ petition, my lords.
This is dated.
Dated 3/7/2024.
So when the proposal is given to you in the month of August, where is the question of you paying 10 lakhs in the month of before that? Proposal is given to you when? The
Before
proposal is given.
giving the proposal, on advice by the authority, to whom the matter was pending for adjudication, before the authority only, this 10 lakhs has been paid, my lords. Prior to that, when the matter is pending before the DRT, I have paid 7 lakhs. And they given a proposal on the advice of the arbitrator on 26/8/2024.
The proposal is given on that day for 17
Please, my
lakhs. That means
Please.
the amount which you have already paid is
Please, my
already
lord.
deducted. After deduction, it is 17
They
lakhs.
are not indicated in that proposal.
then
My
you
lords,
please
may
go
kindly
to-
see, my lords.
Go to the DRT.
If they
and check
ascertain all
this.
those things, I would have ready to give it all the things, my lords.
Now before this court, you show me after. the
Annexure L may
proposal-
kindly see, my lords. They are not indicated after excluding the payments which you made
on
earlier.
the date
This is the due amount is to be required to pay. If that is the communication by them, I would have ready to pay that amount also, my lords. That is not the indication in the letter dated Annexure L, my lords.
Find out from them and whatever remedies available to you. you
Kindly
please
see
avail.
the, my lords, it is not indicated at all. After excluding this,
Only
this is the
concerned
amount
with-
is outstanding for the OTS proposal.
Can only show the court this after 26/8/2024, before this 30, what is the date for that?
30th 9/24.
Between 26/8 and 39/2024, have you paid that 17 lakhs 50,241?
Prior
Show
to that, I have
the
paid,
court.
my lord. Prior to that, I have paid.
Then now I understood your submission. I'll record that. Please come. Agreed with the present petition is filed. Seeking the following prayer. It is the case of the writ petitioner that he has availed the overdraft facility, loan facility on 21/12/2000.
Facilities availed by the D3 R3. I am the stood as surety to the said loan availed by respondent number 3.
The petitioner is a guarantor to the overdraft loan granted to the third respondent. As the third respondent has failed to pay the amount, the bank has initiated the proceedings under the Surface Act. The bank issued a notice dated 1/12/2018 that an amount of rupees 25,40,212 is due. That was replied by the petitioner on 5/1/2019, expressing the intention that they is ready to pay some more rupees 3 lakhs. But the respondents have proceeded further by issuing the notice under section 13(4) of the Act on 4/11/2020. Then the petitioner approached the DRT and initially stay was granted by the order dated 18/8/2023 that the petitioner shall pay some more rupees 25,000 within 3 installments. By virtue of that, he was constrained to pay rupees 7 lakhs on 21/8/2023, 30/8/2023, and on 15/9/2023. Thereby, the order of the DRT is fully complied. By virtue of the interim order the auction sale of the property came to an end. Thereafter, the respondent bank has approached the jurisdictional magistrate and filed criminal miscellaneous number 2502 of 2023, and an order was passed under section 14 of the Act on 13/6/2022. The petitioner, by letter dated 8/4/2024, has expressed that he is ready to clear the entire amount. Then he has sent a legal notice when did he avail the loan?
No, it was, loan was availed in the year 2000, please.
2000.
Year 2000.
2000. That is correct.
Correct.
Legal notice was sent on 17/8/2023 to the first respondent petitioner. It is stated that surprisingly a notice under section 13(2). What is this? What are these dates? Let's look at paragraph number 10. You talk about 2024 proceedings, again 13(2) notice on 25/4.
Prior to that proceedings, my lords. The letter of exchanges as made with the bank. I given a letter on 8/4/2004 also, and I expressed on 25/4/2014. I've given a letter to the bank also, my lords.
No, where from this 13/2/25/4/2014 has come into picture subsequently?
Please, my lords.
At least in your objection, the vacate, there are facts.
No, I filed my objection statement and I have also
Where is
stated
that? Please come to that.
objection statement. I've taken.
Neither you touch the.
No, I filed my detailed statement of objections on 11/2/2025, page, my lord.
It's not there on record. Give that. Give a copy of
Please,
it.
please.
When the respondent bank proceeded to conduct e-auction on 4/7/2024, the petitioner has raised a dispute before the additional registrar of cooperative societies and sought stay of the proposed e-auction. With the consent of the respondent number 1 bank, the said e-auction was not proceeded. Petitioner paid a sum of rupees 10 lakhs by way of a demand draft. It's a grievance of the petitioner that as per the OTS letter that is dated 39/2020. What is the letter dated? 30?
OTS dated
26/8/2024. Petitioner has paid the entire amount, and in spite of the same, the respondents are proceeded with the auction. Hence, he has filed the incident writ petition. Land Council appearing for the respondent bank submits that because as proceedings were pending before the additional register of cooperative societies and pursuant to the directions issued therein, the petitioner submitted a request to the respondent number 1 bank seeking one-time settlement of the outstanding loan amount. Accordingly, in compliance with the said direction and without prejudice to its rights and contention, the respondent bank issued a letter dated 26/8/2024 communicating the OTS amount of rupees 17,50,241 being the amount due as on the relevant date, excluding the payments already made. The one-time settlement proposal was not accepted by the petitioner. Then the respondent bank proceeded to conduct the e-auction on 29/2024, and the highest bidder had paid the entire amount in accordance with the rules, paid the entire amount. It is stated that the present writ petition is not maintainable. The petition has an efficacious remedy under Section 17 of the Surface Act. Next part. Having heard the counsels on either side, there is a material on record. The writ petition, the prayer that is sought before this court is to quash the communication letter dated 29/2024. By virtue of the said letter, the respondents have informed the petitioner that the auction had taken place. If this communication is set aside, and how the petitioner would be placed in a better position, this court is not able to understand. If the petitioner is aggrieved by the e-auction that is conducted by the respondent, he would have questioned the same, and he would have made the auction purchaser also a party to these proceedings. By quashing the communication dated 29/2024, no useful purpose would be served. That apart, the contention of the land counsel for the petitioner is that he has already paid more than 17 lakhs and odd, as that is offered as per the the one-time settlement. The the letter that is issued by the bank is on 26/8/2024. According to him, he has paid an amount of rupees 10 lakhs prior to that. Then as per the one-time settlement, it has to be by 30/9/2024. Nothing is forthcoming to show that he has paid an amount of rupees 17 lakhs and odd between 26/8/2024 and 30/9/2024. According to the petitioner, the respondents have not deducted the said amount. If that is the case, the petitioner ought to have communicated the same to the respondent. When they have addressed a letter on 26/8/2024, petitioner has kept quiet till 30/9/2024 and then has come up before this court raising all these grounds. The writ petition as placed before this court cannot be entertained by this court. Further, stay is granted in this.
Yes, please.
Please, ma'am. Annexure N
Not
is the
to issue
communication.
sale
my lords.
certificate.
On 6/11/2024, a coordinate bench of this court had directed the matter to be listed on 15/11/2024. Till then, respondent number 1 and 2 shall not issue sale certificate in favor of the auction purchaser. Then that interim order has been continued, has been extended from time to time. The petitioner is not entitled for any relief from this court. And the writ petition, he cannot file a writ petition questioning a communication without even assailing any of the proceedings that are initiated by the bank under the Surface Act. In that view of the matter, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy, if any, in accordance with it.
My lords, interim protection may be
Filed
continued.
an
my lords.
NOC wakalat, my name is not shown, please.
So and so, as filed in
Ramesh, I
Wakalat,
The interim
Yes.
protection may be continued, my lords, interim protection may be continued, my lords, till for 2 weeks, my lords, to file a appeal before the DRT.
Protection, they have deposited the entire amount, please, my lord, from more than 1.5 years, they are referring this
That's
action.
what is so
purchase.
unfortunate. A person who comes to the court saying that you set aside the letter issued by the bank without even questioning the auction notification, auction proceedings, without making the auction purchaser a party, enjoys a stay from 24 and says you should be protected for another.
Like, we have communicated on the as per annexure N, my lords, subsequently after the letter.
This is not a case where we can grant interim protection. Yes, next.
Great.
Not required. Yes.
Serial number 4.
Lord, I appear for the respondent bank, my lord.
You complied the interim order, Your Honor. Paid the entire.
You argue the main matter.
Interim order is not complied, my lord.
Paid, Your Honor.
It is complied.
Complied.
My lord, your lordship may kindly see order dated 21/1/2025, my lord. This honorable court has passed an order, my lord, where he himself admitted, my lord, that he deposited only 7 lakhs. And the interim order is of October 2024, my lord. They have enjoyed the interim order for more than 1.5 years, my lord. And now,
On 20,
now are, my lord,
on
63 lakhs, my lord.
Lordship, on 23/1/25, I filed memo for depositing intimation.
23.
1/2/25. I paid the
Anyhow,
1
we
lakh.
will hear the matter now that stage has gone. It's a 24 writ petition.
The housing,
Please argue the main writ petition.
housing loan here.
Whatever is the loan, we'll hear the matter. Because it doesn't make any difference.
There is the petitioner annexure B is the,
What have you questioned?
I questioned the vacating notice here.
What is wrong with the vacating notice? What is wrong with the vacating notice?
You have not given, you mentioned the amount you are under in that, which amount is due. That's one not mentioned in this vacating notice.
Before that 13-2 notice is issued,
Yes,
you have replied to 13-2 notice.
yes, yes.
Then
Now annexure B, he has entered one sale agreement.
notice is a consequential to 14 order. Isn't it? So have you questioned that order? Then without questioning all that, how can you come before the court? Even now, what is outstanding amount as on today?
17 lakh, the 30 lakh, in that 7 lakh has paid your honor.
So remaining amount, when will you pay?
I'll pay within 3 months here.
Then file an
I
affidavit.
entered one agreement.
File an affidavit. If you file an affidavit on that affidavit, I
One
dispose of
week
the-
time may be given.
Yes. This is matter as part of next week.
My lord, may I
The
make?
petition- Yes.
My lord, there is one more connected matter, my lord, where he's challenged another vacation notice, that is WP 666-9 of 2024.
And that also vacate, that
will-
also stays there.
Same, my lord. Your lordship may connect.
List along with so and so by the next, as parted, by the next date of hearing,
WP
the
number.
petitioner shall file an affidavit before this court. When that within, it is submitted that he'll pay the amount within 3 weeks, the 3 months, an undertaking affidavit shall be filed before this court, or else the writ petition shall be dismissed on the next date of hearing. Yes, 5.
Sir, connect the
666-9
WP number.
2024.
Connect the WP number.
666-9 of 2024, please.
666.
9 of 2024.
Serial number 5, Sandhya U. Prabhu, for petitioner Vignesh Shetty.
Lord, I may permit to file the memo.
Just now the copy has been served, my lord, the calculation. This is a case where, my lord.
I remember.
Yes, my lord.
Next week.
Please.
Maybe taken on.
The counsel for the respondent is placed on record, submits that he'll file the
Memo.
the details pertaining to the expenses borne by the respondent. A copy of it is already served on the counsel for the petitioner. This is matter next week.
Serial number 6.
April.
Can be fixed, my lord. Date, my lord. If not, it's okay.
This is matter on 5th of March.
5th.
Yes.
Serial number 6.
The petitioner shall file if any
Affair for
objection.
petitioner.
Yes, 6.
Serial number 6, Rennie Sebastian.
Affair for petitioner. Mary.
Yes.
Extend of time.
This court, by order dated 23/8/2025, has directed the family court to (15/12/2025). Now a letter is addressed by the second additional principal judge, family court, seeking a week's another 1 month time. Considering the request, the writ petition is disposed of. Considering the same, 1 month time is another 1 month time is granted for disposal of the GNWC.
Serial number 7, Naveed Ahmed for petitioner Satish
Petitioner,
P.
Lords.
Respond number 1, my lords.
Lords, challenges, my lords, to the, my lords, the possession notice issued by the bank, my lords. Lords, I'm a tenant, my lords. But this property was, my lords, leased out to the, my lords, to the petitioner, lords, prior to the mortgage, my lords. Lords, kindly see the date of
Your lease is?
prior to the mortgage.
No, by way of?
Registered lease, my lords.
My lords, after our, their registered lease is only for a period, locking period for 3 years, my lord, which was expired on 30/9/2024. After that, my lords, we proceeded with the SARFAESI proceedings and we issued 13-4 notice. My lord, we issued 13-4 notice on 12/8/2025.
Lords, I agree, my lords. The lease is not on 39/2021 for a period of 3 years. I have paid, my lords, security deposit, my lords, 50 lakhs. That security deposit, my lords, refundable security, interest-free refundable security deposit, my lords, under the agreement itself, my lords.
No, that is true.
Let me complete, my lords. Let me complete. Lord, day after, my lord, there is a clause under the agreement that the lease can be extended subject to, my lords, mutual.
Tenure cannot be done in the light of the mortgage that is entered.
No, that cannot be done, my lords. The bank, my lords, kindly see the due diligence of the bank, my lords.
It is extendable. Did they extend it?
But they are continuing, my lords.
Not, it has to be by way of a registered agreement.
No, my lord, not required. Kindly see the lease itself, my lords. By mutually, they can go ahead, my lords. They can extend the lease, my lords. The lease agreement is very clear, my lords. And lords, did you kindly see the due diligence of the bank, my lords? When the property is, my lords, lease, registered lease, but they would have seen at least an incumbent certificate, my lords. Without seeing the incumbent certificate, my lords, the bank is proceeding with the, my lords, with the loan, my lords. That's how can the, my lords, kindly see the bona fide of the bank? Lords, unless, my lords, my money is, my lords, refunded, my lords, let them, my lords, I am interested only with my money, my lords. If my money is paid back today, I will vacate the premises today itself. Why should I hold on?
Yes.
My lord, this is the practice of the bank, my lords. My lords, they, my lords, what they do, my lords, they will immediately they will issue the loan, my lords, for a property which is not fetching that much amount. My lords, now, my lords, they start harassing the tenants, my lords. They, my lord, the borrowers are absconding. They are not, in town. Lords, ultimately the tenant is, my lords, facing the difficulty. Therefore, my lords, once there is a prior mortgage, lords, let them, lords.
Prior mortgage, which was expired on
2024.
39/2024.
Yes.
I'm not.
Let him come.
Lords, unless my money is, my lords, secured, lords, how can I vacate the premises, my lords?
Yes.
Therefore, my lords, the notice has to be set aside, taking into consideration, my lord, prior mortgage and the bona fides of the bank while extending the loan facility to the petition to the, my lords, borrowers.
Yes.
My lords, in our objections we have filed, we have stated that after the lock-in period was over, 39/2024, they mutually did not agree to extend the lease agreement. And my lords, it is interesting to see that we issued our possession notice was issued on 12/8/2025, my lords. That's almost a year after their lease agreement was over. The lock-in period had over. Now, my lords, till that time, they had issued a notice to the respondent number 2 to 4 on 10/9/2025, my lords. 10/9/2025, after issuing our 13/4 notice, they have issued a notice to the respondent number 2 to 4, claiming their money back in the lease agreement they had returned. My lords, when the 13/4 notice was issued, previously they did not take any steps. They were mute spectators. They did not take any action towards their claiming of the amount. After the 13/4 notice was issued, they have issued the notice which is dated 10/9/2025. That is almost a month again after our notice was issued, my lord. My lord, in our objections also, we have also stated that we have granted loan to respondent number 2 to 4, stating that in the sanction letter may be seen, my lord, page number 4, annexure A in our objections. We have granted loan in that the respondent 2 to 4 have stated that they have a business named as Risha Furnitures. And my lords, in the lease agreement also, the respondent number petitioners have also stated they are also running a business. Now, my lords, in their agreement, the lease agreement, they did not mention on which type of, in the nature also, they did not mention in under which name they are running the furniture business. And my lords, in our loan application also, Risha Furnitures, they are dealing with the furniture of retail and sofas, my lord. In the lease agreement also, in the nature, they are mentioned that they are also dealing with furniture and sofas and retail, my lords. But under which banner, under which name, they are not mentioned, my lords. My lords, there is the only our objection is they created a registered mortgage deal, lease agreement, and later they sanctioned loan from us. And after when we proceeded with the SARFAESI proceedings, for 1 year they have not taken any coercive steps for claiming their money back. When we issued 13/4 notice, only they are remembering that we need to take our money back from them, and they issued a notice. So, my lord, our only contention is that they both are colluding with each other, and interim order may be vacated, and petition may be dismissed.
Yes.
My interest has to be protected, my lords.
My lords,
my interest, my lords, has to be protected, my lords.
For 1 year, they did not take any steps, my lord.
I'm sorry, my lords, the lease was continuing, my lords. They have renewed the lease. That itself shows. That itself shows not the lease was renewed.
39/2024, the lease got over.
Any renewal of any agreement is fine before.
No, my lords.
Let's kindly see the lease. Five moment, my lords. Kindly see the lease agreement, my lords.
No, first lease would be for a registered lease. Then is it your submission that extension would be oral extension?
Kindly see the lease agreement 5 moment, lord. Just for my satisfaction, I will read, my lords. Page 15, enhancement and renewal. The term of lease subsequent to the 3 years may be extended by mutual consent under such terms and conditions as may be mutually agreed between the parties at the time of renewal, and at the end of which the either party, that is lessor and lessee, can terminate the lease after giving 3 months advance notice in writing. Plus, even after the expiry as on 31st October 2024, I am continuously paying the rent to the lessors. Therefore, the mutual understanding is this, the lease is renewed.
Yes.
Up till the notice is issued. The moment the notice is issued, I said, stop now. Kindly give me money back.
My lords, their submission in their petition itself, on page number 4, second paragraph, they itself have mentioned the petitioner about the expiry of the lease on 39/2024, expressed their willingness to vacate, subject to refund of the security deposit. They expressed they want to vacate, my lord.
Yes.
And then subject to refund of the money, my lord.
Subject to
Till
refund.
1 year, they did not take any steps. Why is that? They did not take any steps to protect their.
But I started paying. I continuously started paying the rents.
Let him complete.
Yes, Lord.
Has to argue.
Yes, my lord. In the second paragraph, they itself have stated that they agreed to vacate. They did not continue the lease agreement. They did not willingly say that we need to continue. They had not been paying rent after that, my lord. 50 lakh amount, they told they need protection from here, my lord. They have taken interim protection, and my lord, on when we have taken possession notice, symbolic possession notice, it was issued. Only 1 month later, they have issued the notice, my lord, to the respondent number 2 to 4, stating that we need our money back. When the protection, they had the time limit. Before also, they did not take any steps.
So you have already submitted all this.
Yes.
Yes, third result.
Obliged.
Not required.
That's interim order to continue, my lords.
Cell number 8.
That's interim order to continue, my lords.
Interim order will be continuing when I
Obliged.
resolve the matter.
Obliged.
Yes.
Cell number 8. HSVKV for petitioner.
For the petitioner, this is the matter where, my lord, there are 2 insurance certificates got produced and marked, which is exhibit R1 and R6. R6 is the insurance certificate produced by the petitioner herein, who is the insurer. The insurance company has produced exhibit.
That there is a valid insurance policy and the tribunal had rightly fixed the liability. Suppressing this fact, it was submitted before this court, that this court allowed the appeal. Yes.
So, my lord, now the issue number 2 framed by the trial court, my lord.
Page number.
Page number. Lordship will get it, the judgment. The impugned judgment, lordship will get page number. Page 24 is the issue number 2, my lord.
Insurance company proves that there was no policy coverage in respect of tractor and trailer.
Trailer bearing registration number so and so. For which, my lord, the finding lordship will get at page paragraph number 8, page 29.
Paragraph number
8.
Yes.
As I have already said above, the petitioner has proved that the accident has been taken place in the place, date and time alleged, and due to which Basuraju is dead. The petitioner has also proved that the accident is due to rash and negligent driving of the driver of the tractor and the trailer. It is not in dispute that the respondent number 1 is the owner of the vehicle and respondent number 2 is the insurer of the vehicle. Hence, both are liable to.
Where is the discussion? When
there is
an
no
issue
discussion.
When an issue is framed,
correct.
That's what they submitted when.
No,
the
no, no.
matter
That's
was
what
heard.
I submitted. They say that, my lord.
Not here, in my order itself.
In the order. On that day, I was not there. I was placed.
That's what I've recorded.
Correct.
No, there is an issue, but they're saying that that is not the policy issued by them, and whatever is the policy that is not subsisting as on that day. No, in that case, there should be a finding by the court.
That's what, my lord, the trial court should have given a finding that which policy is valid and which is the genuine policy, which is not there, which is not forthcoming in the.
Set aside this order and remand the matter back. Please. Yes, please come. This court.
Subject to condition, my lord, if he want to adduce evidence or to place any record. Otherwise, all the records here, your lordship can. If he wanted to rely upon or to examine any other.
Where is the document? That document is not part of the record.
No, he has produced the document, adduced the evidence before the court. That's the reason, my lord.
See that then.
It is there.
Yes, where is that?
Exhibit D6, lordship.
D6 is the mark by him.
Page number 48 to the paper.
Original records have come.
Records has come.
It is.
Exhibit
D6.
dated
D6, my lord, exhibit D6 is dated
29/5/2008.
29/5/2008 to 28/5/2009. But what they are contending, that, my lord, according to that, your lordship, down, they have paid the premium on 4/6/2008.
4/6?
2008.
According to them.
How they paid the premium?
The agent
But
of the
the
insurance
policy,
company.
according to them, policy was issued much prior to that, according to them, as per that policy. Therefore, what we have done, my lord,
Please come to this exhibit D6.
Please.
Look at D6. Point out what it is. Come, let's see what is mentioned there.
please. Six.
Policy 48.
In this, my lord, your lordship kindly see, we have taken the context of this policy. This document is created one, which was not issued by us. In that, in support of that, my lord, your lordship kindly see.
No, first of all, come to D6. Come to D6. The document.
No, please.
Look at the document and submit. What is it? What the document? What are the contents of it? When is it? Policy issued on 27/5/2008.
Correct. According to them.
According to this document.
Please.
27/5/2008.
Please.
Yes.
This is the document. He says that, my lord, which was issued by the insurance company. He has paid the premium to one employee.
Where will you get that?
That is in the evidence, my lord.
He says that in the employee. That's what, my lord. He says that he has paid some amount to some person. He has given this policy. My lord, we have produced the proposal form on the inward register, and the vehicle was inspected by us, and premium was received for that. There is
he was your authorized agent.
Please.
Then what is the?
We will leave the whatever the amount paid to the company or to the agent, they will issue a receipt.
No receipt.
Then he has not placing the receipt, my lord. What he has, it is mentioned in our policy. There is a receipt number which was issued on 4/6. The very same number he producing this policy. Receipt numbered and date is 4/6.
Premium collected details 4/6/2018.
Please.
2008.
Right. How he can give, when the policy was issued much prior to the accident, he has paid the premium amount according to him after the accident.
Yes.
It is a created document.
My lord, I have a simple explanation to this, my lord. When I pay the amount to the agent, he will not issue the receipt at the spot because he will come to the place.
Forget about it. How can your policy is issued on 27/5/2008, and you say that I paid the money on 4/6? Without paying the money, will they issue the policy?
That's what, my lord. What happens is, my lord, whenever the policies are due, these agents, because it is a remote village, they will create the policy, come to my place, collect the amount, my lord. That is how the system works. My lord, see, agents works for the insurance company, my lord. All the agents works based on the trust.
When the insurance company is denying the insurance policy, no insurance company will give a policy like this, saying that you paid the money premium on 4/6. I have issued this insurance about a month before. A month before. How will they do it?
No, what happens, my lord? The agents, my lord, on their own, telephonically, my lord, they will go to the insurance company, pay the insurance and collect the policy. And thereafter, my lord, on some other date, he will come to my place, collect the amount by cash. At that time, my lord, if he has carried the
but he will not mention it in the insurance policy. That's an arrangement between you and the
my agent, or the agent, my lord, is none other than their agent.
No. Agent will never mention that I have taken the money subsequent to the policy. He would be paying, if it is, he would be paying from his pocket and then he'll collect it from you. The day would be mentioned much prior to the policy date, but not later. That should be the finding of the court, which was not given.
There is no finding at all, my
Now
lord.
I'll give the finding, basing on this policy.
My lord.
It can't be, we can't believe this kind of a document. They have every basis. I can understand if this is not there.
Lordship, may kindly for a moment see the cross-examination of this or the evidence of this,
Cross-examination of whom?
of the insurer.
Hmm.
My lord. The line starts with the cross-examination, my lord, he is an illiterate. Nanige ಓದಲು ಬರೆಯಲು ಬರಲ್ಲ, which means, my lord, he doesn't know what is happening, who has given the policy and whether he has to collect the receipt or not.
This is very simple.
Hmm.
If it is given by the insurance company, it won't be, you will not find this kind of the premium paid subsequent to the policy of insurance. Without taking the money, how can they give insurance to you?
My lord, that's what, my lord, when the person who is an illiterate, who cannot.
But we can't help it. Please come. This court on, when is the date of disposal?
The judgment on 14th September 23.
There is a judgment.
Annexure H, page 13, annexure A.
Page number 13.
This court on 4th September 2023 has allowed the appeal filed by the insurance company. While allowing the appeal, this court has specifically observed as follows. Extract the entire paragraph number 4. Now the petition is filed by the owner of the vehicle, stating that no notice is served on them. Considering the same, this court has entertained the review petition, and while advancing the arguments, learned counsel for the petitioner submits that there are two policies, that is exhibit
R1 and D1 and D6.
Exhibit D1 and D6. When there is a policy existing, a submission was made before this court that there was no policy, and basing on that, the court has exonerated the insurance company from the liability. On the last occasion, considering the submission of the land counsel for the petitioner, this, as it is submitted that the execution petition is filed, this court had stayed all further proceedings. Today, when the matter came up, land counsel for the respondent insurance company has drawn the attention of this court to D6. As per D6, the premium was paid on 4/6/2008, and the policy was issued on 27/5/2008. Land counsel submits that they have adduced evidence on behalf of the insurance company to show that we have not received any amount. They have not received any amount, any premium amount, and according to them, they have paid it to an agent. It is submitted that there is no policy, they have not issued the policy, and though there is no finding by the tribunal on that aspect with regard to exhibit D1 and D6, as the entire material is before this court, now this court may examine the same in the light of the evidence that is let in. Land counsel appearing for the petitioner submits that petitioner is an illiterate. As per the procedure in vogue in the villages, he has paid the amount, and the policy is issued. He is not acquainted with all these procedural intricacies, and it is submitted that if the matter is remanded to the court, as there is no finding in the order, the same could be appreciated by the court.
And one more submission, my lord, I am ready to produce the receipt, whatever which I have
We
received.
submitted that they are ready to produce the receipt that they have received from the agent. Next part. Having heard the counsels on either side, there is a material on record.
And also in the cross-examination, my lord, it has been denied that the amount has been paid on 4/6/2008.
It is, and in the submissions, in the cross-examination, it is denied that an amount is paid on
4/6/2000.
4/6/2008. Next paragraph. Having heard so and so, when there are two policies, D1 and D6, and when the petitioner is relying on D6, as per the policy, when the premium is paid on 4/6, the policy was issued on 27/5, and they have placed certain material before the court to show that they have not received any amount. As far as the petitioner is concerned, except denying the fact that, except stating the fact he is an illiterate, nothing has been put forth. And at the same time, the court has not made any inquiry, but court relied on D6 and held the insurance company liable. This court has perused D6 as rightly argued by the Land Council. The policy was issued on for 27/5, and the premium amount is paid on 4/6/2008. The amount.
There is no material placed by the insurance company to show that.
Sufficient. This
They have
is
placed
sufficient.
record.
You have, now the burden lies on you. Because when something is done, contrary with your document itself is speaking document. So it is contra, that's for you, not for them. I have already adduced evidence to show that they have not received money. You should have examined the agent. It is not possible. What did you write? Then counsel for that? On 4/6/2008, on the face of it, it falsifies the contention of the petitioner, owner of the vehicle, and you to substantiate that, except the policy, he has not adduced any evidence. In the considered opinion of the court, the trial court, without any basis, has fixed the liability on the insurance company, and this court has rightly allowed the appeal filed by the insurance company. This court do not find any reasons in the review petition. The petitioner could not make out any grounds to review the order dated so and so. Accordingly dismissed.
Much.
Delay in filing is condoned.
Cell number 9. Cell number 9, Vasudevan.
Petitioner in this case, my lord. But previously, I had filed my memo of retirement, and today they have again given a wakalat to me. May I permit to file it in the counter?
To argue that can't be. What is this?
No, my lord, that retirement memo was filed in the month of October itself. There was some
Whatever it
other.
is, no, it's for them to engage the council and get ready with the order.
Please, my lord.
And now,
Previously, my lord,
one day it's convenient to give up the
no, my lord,
wakalat.
there was some other developments in between. My lord, we had previously briefed Mr. Dhyan Chinappa to argue this matter, and today is not available. Date may be kindly fixed, my lord, so we'll go ahead with the
I will
matter.
submit this.
As per their convenience itself. I'm not seeking for any.
1 minute.
Sorry.
This matter has been going on like this. In the meanwhile, IBC proceedings were taken up. Twice it went up to Honorable Supreme Court. NCLT has ordered winding up of this liquidation of this company. Challenged before NCLAT, it was remanded, again went back to NCLAT. NCLAT has ordered winding up in 2021. Now the Honorable Supreme Court, my lords, in its latest judgment, has upheld the order of the NCLAT, dismissed their civil appeal, and all contentions. This is on, my lords, February 12, 2026. So now, my lords, to say adjourn it, and all contentions, this is only an order passed by the DRT which is challenged before, my lords. They don't even go to DRAT.
No, DRAT order. I'm sorry. It is a DRAT order. It's saying the DRAT.
I think, my lords,
I'm sorry.
if I stand corrected, it
No,
is
I'm sorry. The DRAT Chennai, because the value was
not a
very high, it was
DRAT
transferred.
order.
I'm sorry. I stand corrected. I'm sorry.
No, my
So
lords,
that is
what-
only.
Then probably you must be thinking all the way to travel till Chennai, so it has become DRAT.
No, I'm so sorry, my lord. I
And
stand
my lords,
corrected on
whatever
that.
contentions raised here, same were raised before the Supreme Court regarding
Answer.
answered
aware of
against
that
them,
order?
shifting of
I'm
MPA.
not privy to that. I've not went through that order.
That's my lords, it is by the director because the company was wound up. Today, I don't know whether whose wakalat he has filed because it has to be only a resolution professional. My learned friend says I filed the wakalat today.
No,
The company is gone.
No, matter was came up before last week before NCLT Bangalore also. There also the committee of creditors
this
filed an
order,
application for replacement of the RP. The new RP has not been appointed yet. So that is a status.
And I don't know how they can file a wakalat in a winding
That
up.
is, Please, Mark, that is correct. That is in respect of there. See, apart from the directors of the company, there are guarantors also. This petition is also filed by the guarantors. So, on behalf of the guarantors, the petition still stands.
That is by the second petitioner who went to the Supreme Court.
No. Third petitioner. Third petitioner is also one of the guarantors. Second petitioner is the director of the company.
Third petitioner is wife of second petitioner.
But maybe, but they stand on a different footing altogether because she is an independent guarantor.
Everything now that they lost, that is on 12th February 26.
No, the date may kindly fix. That is only my request, Lord, so that we'll address our arguments. The matter can be taken up.
This is matter on 4th of March.
Obliged.
Cell number 10.
At the request of.
The interim order, my lord, let that.
The interim order, my lords, operating is the stay of the dismissal order. That I considered. That is what I considered because their interim prayer was stay of the dismissal order. I said okay.
What will happen with that interim order?
We'll argue it on next week. We'll let the interim order be continued.
Where is that interim order? Let me see. When was it granted?
Lords, the interim order was granted on 24/4/2024. I considered whatever prayer there was, let them take the interim order what they want.
Please see the interim prayer to that. They never had any objections to that.
Yeah, correct. Because the interim prayer is what?
No, forget about his objection. Why? What is the benefit? It is like a suit is dismissed, it is stayed here.
Stayed.
That's the kind. Interim order earlier granted is extended till the next date of hearing.
Cell number 10. Ravishankar S.
Lords, in this case, my lords, some of the petitioners, lords, counsel is unwell, my lords, and also, my lords, the father ceremony of the on-record counsel, my lords, for the petitioner. And my lords,
I filed the IA for vacating stay. They are enjoying the benefit of the order dated 24/4/2024. After that, they are not paid any amount. It is surface action. It's not maintainable. And the total outstanding at around 16 lakhs. It is a public money, my lady. I'm answerable to the public.
For the petitioner submits as some personal inconvenience to the counsel for the petitioner. Counsel for the respondent submits that they are enjoying the interim order from 24 without paying any amount.
Yes, no, my lords. If we compare
interim order, from a 10% deposit, that's wrong back. That's wrong back.
Well, one second.
Kindly let me permit. Long back. In each occasion, they are seeking the time for no reason, my lady. Kindly have a look at the order dated 21/2/2020.
Please consider some personal difficulties. Father ceremony is there.
Yes.
It is submitted that it is land counsel for the petition seeks time submitting that there is personal inconvenience. Land counsel for the respondent submits that the petitioner has obtained an interim order in the year 2024 and the surface proceedings are stayed. It is submitted that the petition is not maintainable. The petitioner has an effective alternative remedy before the DRT. Next part. Considering the fact that there is a personal inconvenience to the petitioner, this is matter in the next week.
And my lord, kindly extend, my lords.
Maybe give me a last chance, my lady.
As a last chance.
Great.
It's a order earlier granted is extended till then.
Next date.
Please.
Next.
This is a matter on 6th of February or 6th of March.
Yes, ma'am.
My lords, 8th, my lords, 8th or 9th.
Why?
Or before 6th, my lords. There is a function in our office, my lords. The senior office, 4th or 5th or 6th, 7th, my lords, function is there, my lord. Please, my lords. 6th, 7th, my lord. Kindly appreciate it. 5th before 6th, my lords.
It's on 10th.
Yes, 10th is fine.
Yes.
Cell number 11.
Grateful.
First time for
Kumar K.
respondent, Your Worship.
Appear for petitioner.
The account has been closed, Your Worship. You have settled the matter.
Huh?
The account is closed. Loan account is closed.
It's closed.
Yes.
When the matter came out, the petition is filed the following prayer. Then counsel appearing for the respondent submits that the entire amount is cleared and the loan account is closed. Considering the same, the petition is dismissed as infructuous. Recording the same, the petition is closed.
Cell number 12. Rajshekar S. Well.
Lords, the total outstanding, lords, it's loan was obtained, lords, 20 lakhs. Subsequent, lords, section 14 order came into pass, lords, wherein they have stated, lords, 17 lakhs is due. Thereafter, lords, a challenge before the DRT. DRT, lords, total there is conditional order, lords, 3,40,000 has been paid. Subsequent note which was dismissed, that has been challenged before this honorable. Notes pursuant to order of this court, notes 5 lakhs already deposited. Total notes 8,40,000 notes has been deposited.
What is the remaining amount?
Notes, the last statement note, the stated 36 lakhs notes. But notes, this honorable court directed us to notes file affidavit. Some,
Where is the counsel for the respondent? No representation on behalf of the respondent. Counsel for the petition is present. This is matter after 4 weeks. Interim order earlier interim order is there.
please notes, subject to payment note which I have complied.
Interim order granted earlier is extended until further orders.
13 and 14 again. Till number 15. V. Mohan for petitioner.
Yes.
And the yes.
No representation on behalf of the petitioner.
I appear for the respondent number 2, my lord. Respondent number 2 is expired.
Land counsel for the respondent submits that the second respondent is no more, and he'll inform he will furnish the details to the petitioner. Yes, list this matter for dismissal after 2 weeks.
Much obliged.
16. Keshava Bhatia.
I appear for respondent number 1, bank notes.
But the petitioner is a director of a company, my lord, called Sound Shelters. Lord, there was another company, my lord, where they were directors. It was called as Dream Logistics. This Dream company, my lord, had borrowed huge loan.
Sitting aside the communication sent by the bank. What is the communication? Your prayer is that issue a writ of.
My lord, prayer is now, my lord, this company had given. I had personally given security, my lord, to lift the movables. To lift the movables, because immovable property was given as a security. That property was sold and the.
Is it the case? Has it come up on the last occasion?
Your lordship heard it, I think.
Yes, the other one is disputing it, saying
Yes,
that the
yes,
property
yes,
should be 50-50.
Yes.
50-50.
It was the
What is to be done?
it was the company's movable property, my lords. He
Property belongs to the company.
Yes.
You have taken the movables.
Yes.
And you have enjoyed it. And you have given some 50 lakhs towards
As
the
guarantee.
Security, as a
security. Now what he says is correct. Half will go to him. He is also a director.
But the security was given by me exclusively,
But
my person.
movables, where have they gone? They were being exclusively used by you.
But I felt the objection also. That the whole property will not was.
15.
What happened to that? No dismissal after 2 weeks. Yes.
That's all. That's all.
The bank is ready. What the bank wants to do?
Lords, we will give the money to whoever
Huh?
my lords directs us to give, my lords.
No, it's not about.
Bank is.
I'll ask that money to be given to the court officer.
No, my lords.
Consistently, my lord, the bank is maintaining that it should be divided, my lord, among both.
Lords, Annexure R2 may be
He's saying
seen.
whoever the court directs, you give it to the court officer.
Lords, Annexure R2 may be seen for a moment.
Huh?
R2, Annexure R2. Lords, he had deposited. We said that you give us an NOC from the other director who is the R2 now, and we'll release the money in your favor, which he didn't do since 2016. In 2019, he files a writ petition without making R2 a party, my lords. Only.
So what is to be done now? Let's say, I'll say both of your directors of the company equally entitled for the
But
movable.
he has ceased to be a director now.
But he was then.
He was there.
He was then, and at that point of
Then
time, he's
he-
also entitled.
In the light of what has been pointed out to me, the order should be, my lord, to return this 50-50 to the petitioner and the implemented respondent.
55-45. That is the ratio of the gold.
Very good, very good. 55 for me and 45.
55 for the.
Why?
That is the ratio. Not just to give a background.
Entire amount is given by me, my lord. Entire amount is given by me, and
His money from a long time.
and he did not pay. He did not shift it.
He'll say 50.
I'll not insist. 50-50.
Not that, my lord, I have considered.
Yes. The present petition is filed. Sing the following prayer. The petition is, it's a case of the petitioner that is one of the two directors of the company which has mortgaged the property, movable property for the loan availed by the company. When the loan was not repaid, the respondents have initiated the proceedings under the Surface Act, and the auction was scheduled on 24/8/2026. And an amount of rupees 16 crores was recovered. The bank had called upon the directors of the company to lift the movable assets which was lying in the auction premises. Petitioner, being the director, had sought for has approached the bank to take delivery of the movables, and the bank has insisted for a security deposit of 55 lakhs, which was furnished by the petitioner, that is one of the director. The petitioner thereafter has approached the bank to release a deposited amount of rupees 55 lakhs. But the respondent bank insisted on releasing the fund once a resolution is passed by the company.
Security. Security, not cost.
Security.
Security.
It is the grievance of the petitioner that when he has deposited an amount of rupees 55 lakhs, now a resolution is not required. Further, the company, the other director is no more a director of the company.
His contention.
As such, no such resolution is required. Hence, he has filed the present writ petition seeking to quash the communication issued by the bank. Learned counsel appearing for the respondent bank submits that the bank is ready to give the money provided the directors come forward or a resolution is passed, and without that they cannot release the amount. Next parallel, counsel appearing for the second respondent submits that as no, he does not dispute the fact that he is no more a director, he ceased to be a director of the company.
That I dispute. I claim that still.
Just now you said.
No, that is his contention. That's what I
No,
said.
when you just said no, you are no more a director. You said yes.
I continue to be the director, and even the ROC documents will not, along with the statement of
It
objection.
is the contention of the land council appearing for the second respondent that he is continued to be the director, and as per the ratio, he is entitled for 55%. The respondent is entitled.
His contention only because it is admitted in an
No, I said so. The petition is entitled to 45%, 45% of the security deposit, which is in response to that, land council, the petitioner submits that he has given this amount as 55 lakhs of security deposit in the year.
In my personal capacity,
The year
2016.
2000, which year?
2016, man.
In the year 2016.
2016.
And the respondent is not, you're the second respondent.
Second
respondent is not entitled for any share. Next for having other counsels on either side, peruse the material on record. According to the petitioner, the second respondent ceased to be a director. However, he does not dispute the fact as on the day the auction was conducted, as on the day the movables were taken by the petitioner, he was not the director. According to the respondent, even till now, he continues to be a director. Be that as it may, considering the fact that as on the date when the movables were taken by the petitioner, the respondent number 2 was a director. And when that property belongs to the company and both of them are entitled for a share in that, according to the second respondent is entitled for 55% of the same, and the petitioner is entitled for 45%. Considering the fact that in the year 2016, the petitioner has given the security deposit of 55 lakhs. This court deems it appropriate to. This court is of the considered opinion that the ends of justice would be met if the amount is equally distributed between the petitioner and the second respondent. In that view of the matter, this court is passing the following order. The writ petition is disposed of, directing the first respondent bank
One request, this entire amount is now paid by me, but the bank has to refund it with some interest.
No, with accrued interest only.
And that interest, the bank has to, it is a nationalized.
They have kept it in FD. Not about 6 months ago, it was about 66 lakhs. Now approximately it's about 1 crore.
That's my only submission was in
With accrued
2000,
interest?
in 2016 itself, 2 days after his communication asking for the repayment, my lords, we have given a clear instructions telling that if you get an NOC,
No, it's a security, it's a fixed deposit, whatever interest accrues, it will come.
lords, they have not acted upon their own undertaking, my lords. Now they cannot claim equity asking me to give them the interest, my lords.
Not interest. If it is in fixed deposit, whatever accrues will accrue.
With accrued interest.
That I will take instructions.
No instructions are required, it's in fixed
It is
deposit.
a bank, it is a bank.
Then,
That's it. It may be a bank, my lords. My only.
oh, security deposit, you will keep it in an account,
Yes.
in a fixed deposit.
Yes.
Whatever interest accrues on that, they are entitled. We are not saying specific interest, whatever is the interest accrued on the amount that is in the fixed deposit.
It's with
Oh.
My objection may be
And
noted
that
to that
interest,
effect.
my lord, I am entitled to the entire right.
Then what about the amount that you have derived from selling the property?
But selling the property, and now of course it is a company property, we are sharing it.
This was not directing the
That's one
respondent.
submission. My objection with respect to the interest may be just noted, my lords.
The directing, I'll record, directing the first respondent to release the release the security deposit along with the accrued interest. I'm not saying give any interest, whatever the accrued interest equally between the petitioner and the second respondent. In his contention response, it is submitted that the bank has to, petitioner's contention that the respondent bank has to pay the interest. Then township with the respondent bank submits that right from 2016,
16, my lords.
the petitioner.
Lords, he waited 3 years to even file this writ petition. my lords.
Petitioner has not
Yes,
taken
left over
any
his
action.
rights.
And after 3 years, he filed this writ petition. Now he cannot insist for the interest to be paid by the bank.
Cell number 17.
I request, my lord, interest, my lord, accrued interest,
But
entire.
what did you do with the mobiles? Yes, next.
Within some time, not within 2 weeks or 4 weeks, within some time.
What problem they have?
Again, I will come back to court.
As soon as we get give them the
2 weeks.
order, will
2 weeks.
2 weeks. Within 2 weeks from the date of receipt of the copy of the.
Please.
Yes.
17. Somchekraya RP for petitioner Narayan Swamy.
Section 14 order has been challenged, madam. Simultaneously, they went to DRT, taken the conditional order, which has been not complied. Immediately after taking the conditional order, they trespassed into the possession of the property which was in my possession and taken back. Again, by getting the subsequent order, I taken physical possession
We'll adjourn this matter.
and I sold the property on 27th
Any
November.
stay in this? Any stay in this matter?
No, madam.
No representation for the petitioner. Counsel with the respondent is present. List this matter for dismissal after 2 weeks.
Any date, Miller? Any date?
It's a matter on 11th of March. Yes, next.
Cell number 18 adjourned. Cell number 19.
Millard, in serial number 18, Millard, I have filed an impleading application in March 2025. It has not been put up, Millard. Kindly the registry may be directed.
Also, the respondent submits that he has filed an implead petition. Registry is directed to put up the same on the next date of hearing. Yes, next.
Cell number 19.
Here for the petitioner in serial number 19, please.
19 may kindly be passed over, my lord.
No passovers today. How is it possible?
This is a petition by a successful bidder seeking refund of money from the respondent number 1. Millards, on the ground that during Millards a publication for the public for auction of the property, Millards, which was undertaken under Rule 8, sub Rule 7 of the Security Interest Enforcement Rules. Millards, they had not declared that there is a pending litigation which was, Millards, created by the loanee or the person who had taken the loan, who had filed a application before the DRT, which he, Millards, subsequently, Millards, succeeded, and the Honorable DRT had directed that the property should be given back to them. Since from 2018, Millards, I have been put to, Millards, that risk And today, in 2024, because of my lords, the Honorable DRT, my lords, was pleased to set aside the sale auction. Subsequently, they assailed it before the DRAT, my lords, which was dismissed. Subsequently, this Honorable Court in 2024 was pleased to remit the matter back to DRT, which my lords held it in their favor. Now they are asking this Honorable Court to, my lords, retrospectively, my lords, give effect to that order of this Honorable Court, stating that in 2024, anyway that we have won it, the auction which we have conducted in the year 2018 is, my lords, held valid. That's why they let the auction purchaser take the property. But 2018, when they had, my contention is that 2018, when they had given the public notice under Rule 8(7), my lords, they had not complied with it, and this non-compliance has been held to be fatal by the Honorable Madras High Court. I pass it on, please.
Yes.
Stating that in the event of a failure by the respondent bank to, my lords, make known any pending litigation.
Yes, the respondent. In fact, I have passed an order where I have granted interest also on that amount.
TP Mutanna, my lord. Advocate TP Mutanna. For
I
respondent.
have also passed one
Please,
order
lords, I could not get that. I will make myself.
where I have granted interest also.
Even I am asking for 12%.
Is this matter?
Short adjournment.
Is this matter next week? Not next week. Is this matter on 12th of March at the request of Land Council, the respondent? Yes, yes.
And this matter, my lord, just make a submission. The respondents have deposited about 2.5 crores or 280 at the directions of this honorable.
Yes.
Sir, my lord will argue.
Where is the file?
12.
Anyhow, we'll hear it 2 weeks.
My lord, this matter is urgent, my lord, 1:30 minutes, because if
I have a bench at, larger bench at one.
then another date may kindly be given.
That's what I've given
12th
already.
March, sir.
How the-
12th March.
12th March.
Yes.
The interim order, may kindly.
Interim order already granted it.
2021 adjourned, cell number 22.
Kindly 3 weeks may be granted, my
Huh?
lord. This honorable court directed to last vacation. Approach the bank, my lord. Some negotiable.
What is that?
No, one-time settlement offer which my lord extended to them, they are not complied. Therefore, my lord, that one-time settlement, my lord, offer is gone. The last occasion they made a submission before this honorable court, I'll approach the bank for a fresh one-time settlement
Counsel
offer.
for the petitioner is permitted to give a proposal for one-time settlement and the respondent bank shall respond to the same within a
My instruction, my lord, there is no one-time
The
settlement.
respondent shall place the same before this court within 4 weeks.
My lord,
Matter in the month of January,
my instruction, my lord, there is no one-time settlement pending before the bank as of now.
as of now.
Aladittu,
You have
old
already
OT.
rejected their.
That is old, my lord, it is part of this appeal memo before this honorable court. That is, my lord, 2024.
My lord.
My lord, kindly come to
What
page
is
number.
this on this order is dated 8/12.
My lord, if you would have given a one-time settlement offer,
He has not given
Not-
after this order.
no.
No, my lord. We give them.
Where is it?
I'll furnish, madam, next date of hearing. Kindly 3 weeks may be granted.
What is the purpose of registering these matters?
There's no point.
My lord. 3 more weeks may be granted, my lord.
This court on 8/12/2025 has passed an order giving liberty to the petitioner to give one-time settlement offer to the bank. The Land Council appearing to the respondent bank submits that the petition has not given up.
As of now, there is no OTS request
The
pending
petition
by
has
the,
not given any proposal.
as of now.
And also that there is no one-time settlement, one-time scheme.
Settlement proposal made by the
Proposal
petitioner
is there,
pending
my-
before me as of now. My lord, there is no scheme as of now. There is no
Then
scheme.
you have to reject it, tell him
It is
that,
not there. As of now, it is not there. My
tell
instruction.
that. You should have told him,
I'm making the submission before.
not to the court. What I said in the order.
That's why, my lord, I am seeking 3 more weeks, my lord.
Some confusion. Lord, kindly come to my lord, page number 99 for a moment. I have given a one-time settlement offer in the year of 2025.
I think you read the order dated 8/12/2025. Where is the order of 8/12? Look at it.
Just open it. Considering the submission of the Land Council to the petitioner, petition is permitted to give proposal for one-time settlement and petition is permitted to give proposal for one-time settlement and the respondent shall respond the same within 4 weeks and respondent shall place the same before the court within 4 weeks. Lord, I am fully aware of this order. My instruction, my lord, there is no one-time settlement offer, request made by the petitioner
So
before.
you will not, everything you will say orally. In spite of
I'll
an
make,
order, you will
I'll
not
file a memo,
respond.
I'll file a memo on that.
Not the memo, you should have responded to that. You should have given a response to him saying that there is no one-time settlement. And why is it waiting from December? Till
May
the
I request
matter is
Milord kindly pass it
listed.
to 2 days, I'll file, Milord, I'll place a memo or affidavit before this honorable court.
This is matter after 2 weeks.
Grateful.
Cell number 23. Cell number 23.
This is a matter where, my lord, we had sought a relief as regards, my lord, overriding effect of the Surface Act over this Buds Act. My lord, this honorable court in an identical circumstance as regards KPID Act has taken a view that this being a central legislation, Surface
There is a
Act,
contra judgment of the Supreme Court.
my lord, as the under the Buds Act, my lord, there is no direct judgment.
Parametria.
No, what I'm saying is, my lord, the entire scheme of the act, if it is looked into,
I have already had an opportunity of hearing this matter.
no, she could tell me.
I had an opportunity of hearing. He has placed several judgments before me. I've seen that.
My lord,
So we
what I would
can't take this judgment into consideration in the light of the Supreme Court judgment.
My lord, the predicament that
Categorically has observed what is the effect of it. What is that?
NSCL judgment, National Spot Exchange Limited.
But that is, my lord, what my lords are pointing out is under, my lord, the enactment which is in pari materia. But what I'm pointing out is, if the entire enactment of Buds Act is looked into, what is laid down in that, my lord, the coordinate bench judgment, my lord, may not be precisely applicable in the sense that this honorable court.
If you again insist further, then we have to hear it and say that how a Supreme Court judgment will apply.
It may be posted for hearing because, my lord, what I'm saying is,
This is matter after 3 weeks.
date may be fixed, my lord, at 2:30 p.m. Some any date your lordship may fix it, we'll close
For
it.
2:30 in my court. List this matters on 16th of March.
So great.
Cell number
My lord, for preliminary
34.
hearing. For preliminary hearing, not in B group. For preliminary hearing. Because it's only a very short matter, again, you'll have to, my lord. If it goes for B group again, my lord.
It will not come before me. It will come before some other court after March.
Let it come in at the stage of preliminary hearing at least. That's my request. For preliminary hearing.
You have an interim order?
No, I don't.
Huh?
I have not sought.
No, the respondents have come on record. So why should be in preliminary hearing now?
Because, my lord, since the matter is very short in a narrow compass, it can
Oh,
be
it's
brought.
not at all short. Yes, next.
Cell number
24.
24.
Appearing for the
Cassius.
respondent.
Suriam.
Appearing for the
Placing a record, Your Lordship.
Huh?
Placing a record before the court,
Huh.
stating that it is till today there is a 3 crores pending. The sale auction is already placed and has been completed.
No, without the petitioner submitting what is his case, you say that record is there, how will I understand the facts of the case? What is the writ petition about?
My lord, in this case, I am the proxy counsel, my lord. Kindly place for a week's accommodation, my lord. Because it was, according to the last order, my lord, the pleading should be
Issue a
complete.
writ of mandamus directing the first respondent bank to accept repayment of outstanding loan as per the settlement agreement dated and restrain the bank from proceeding with the auction.
The auction has been already took place. Your
All kind of prayers are
Sir, on the
permissible.
last hearing date, my lord, I went to the order, my lords, in that they have made submission that there is no any surface case has been initiated under the Securitization Act, my lords. And
Then?
also- but now my learned friend is telling that there already it has been initiated. On the last hearing date, it has been noted by the honorable court, my lords.
Sale deed is also took place.
Yes, this is matter in the month of April.
My lord, on the next month, any date, my lords. Next month, any dates, my lords. There is a tripartite agreement. I am the suffering.
No interim order you have? in
No
that?
interim order for that reason, my lords. Scenery is on the way, has been held up in traffic, my lord.
This is matter on 16th of March.
Grateful, my lords.
Cell number 25. 25. V. Mohan.
Respondent bank.
Divya Purandar.
I undertake to appear with the respondent bank, my lord. I'll file my wakalat. They have sought for sale certificate which is issued in
Challenging the
2023.
sale notice and sale certificate, my lord. No notice, sale notice has been served to the borrower. They sold my property. My value of the property is 1.5 crore. They just sold it for just 60 lakhs, my lord. 50% lesser than the market value. No notice has been served to the borrower.
Is it a first sale?
No, my lord, this is not a first sale. But my lord, it is in 2023. Everything is over. Let them complete the auction purchaser, my lord, because we've already handed over possession.
Is the auction?
Yes, sale certificate only
No
issued
knowledge
23.
about it at all. The OA was going on. Original suit was filed by the bank. Yeah, I was only in the RC proceeding, waiting
But
for the
then
RC
if it is-
proceedings, my lord.
Already you are before the DRT, why can't you?
No,
go?
my
Why
lord,
should
that
you
is the
come
OA,
just
that is original proceedings, not on surface
File
proceedings.
essay. They will file OA, you file essay.
There is no, I have not filed any essay before DRT.
To file now. A auction that is concluded in the year 23, why will we
Because
interfere
here
with
it
that
is a
in 25?
clear fraudulent case between collusion between the auction
And what
purchaser
are
and
the
the bank.
bona fides on the part of the purchaser? You know that a 13-2 notice is issued to you. Proceedings are
They
going
issued
on.
me one-time settlement letter and all. Even now they are asking for one-time settlement. They have suppressed the whole sale proceedings matter before the.
When did you come to know about the sale?
Only recently I came to know only my EC was name was changed. Because the same auction purchaser, there was a civil litigation.
Who is in occupation of the property?
Auction purchaser, my
It is
lord.
auction purchase, it is a vacant land, my lord. There is an already existing civil suit against the same auction purchaser. There was a dispute between the land. He was neighbor to me, the neighbor who participated in the auction. There was already existing civil suit is.
Please question all this before the DRT. That will be the best course available to you. After such a long lapse.
So
of
it
time,
is, since
you
it
make
is a
the-
fraudulent case, I thought I came before the
What will DRT
Honorable High
will
Court.
also decide fraud and make all
They'll
the.
see only the procedural lapse, my lord. They don't see the fraudulent.
Because 23, we can't go back to 23 now. You have to make the auction purchaser also a party. Now they have filed the objections. They have given the details. Who is auction purchaser?
No, my lord, they have not filed objections, but they have only produced a sales certificate where the detail of the
Yeah,
auction purchaser is
details are
there.
there.
Yes, my lord, it's
Then
there.
why you have not made him a party?
Yes, my lord, that is the reason, because it is a fraudulent sale. No knowledge about the sale. Only obtained from the sub-registrar office.
Who is the second respondent?
Already the civil suit is pending against the same person.
I think you understand what the court is asking. You have the sales certificate.
Yes, ma'am.
There are details. Why can't you make the auction purchaser a party? And without making him an auction purchaser a party, how can you seek a relief?
No, I'll make necessary amendment, my lord.
Go before the DRT and make all the arrangements. The writ petition is filed seeking the following prayer. Then counsel for the
The
petition.
delay may be condoned, my lord.
Huh?
The pending before this honorable court, the delay may be condoned.
It is submitted that the bank has played fraud on him and the property is sold half of the market price. And also the neighbor with whom he is having the adjacent landowner with whom he is having the dispute, which is a pending civil suit, has only purchased the property. It is the land council alleges collusion between the bank and the auction purchaser. Land council appearing for the bank submits that auction has taken place in the year 23 and the position is given to the auction purchaser. The petitioner, without making the auction purchaser a party respondent to this writ petition, has filed this writ petition. Further, in view of the alternative remedy available to the petitioner, the present writ petition is not maintainable. Next part, having heard the counsels on either side, there is a material on record. It was conducted in the year 2023. According to the petitioner, it came to his knowledge recently. And there is a fraud, even if there is a fraud played by the bank, the remedy available to the petitioner is to go before the DRT. The petitioner, having known the fact that auction is conducted, he has not made the auction purchaser a party to the best reasons known to him. There is submitted that if an opportunity is given, he will make the party. He will make the auction purchaser a party.
One submission, my lord. Auction purchase is a party in this, second respondent.
You said he is your.
Yeah, I made him as a party in this writ petition, my lord. Sorry, my lord.
Yes.
He is the
Why
second
both of
respondent.
you are making these kind of submissions?
No, my lord, auction purchaser is a sangha, and so therefore.
Yeah, the Sangha only purchased the property, my lord. The dispute is between
Who is
them.
the respondent? Samaja Seva Sangha.
Samaja
Yes,
Seva
ma'am.
Sangha, who is in possession of the property now, my lord, because it's in 2023, we've already handed over.
But he is the auction purchaser. You are saying that he has not been made a party.
No, I'm saying that he's
also
not on
accepted.
record. No, my lord, in any case, it's a question of challenging the
It's
sale.
a
which
different
is-
aspect.
Yes,
Whether
yes,
what
yes.
is the case, but at least both of you have to be clear on facts. He says he
Sorry,
also
ma'am.
accepts
No,
that
ma'am.
auction purchaser is not made a party. Not making a party that you remove. Considering the, what is that? That you remove, delete that. Considering the fact that the auction is conducted in the year 2023 and the auction purchaser in possession of the property. All these disputes can be decided by the DRT and the petitioner ought not to have come before this court when there is an effective alternative remedy. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. However, petitioner will have the benefit of section 14 of the
Section 14.
Limitation Act.
Case number 26, parted VM Chidappa for petitioner. Vignesh Shetty.
The Lordship has ordered to file the affidavit. But what has happened is he has signed on only one side of the affidavit and sent it to me. So the notary people is telling that another side also should be signed. So 1 week time should be, if in the Ramzan month is
the
going.
last 2 date order passed with this honorable court given an opportunity. 2 occasions, 2024 from that date.
What he is telling,
They are not paid anything
when
after that.
our party is going to
FTA one
bank,
reason.
taking 2 lakhs, 3 lakhs, bank is not accepting his cash. What, and he has also got our, all documents are with him and more.
You can't argue anything when you have not taken steps to get the affidavit as required. No, you can't point out at the bank and say that so and so is wrong with the bank. It's your fault not filing an affidavit.
Madam, affidavit I am accepting, madam, but when my client is going and he is going and approaching the bank for one time
I'm not
settlement,
concerned with all that. I'm only on the point.
a week's time I will give a ready affidavit. I will give, I'm just asking a week's time and the month of Holy Ramzan is going on. That's why I'm.
Kindly see the order passed by this honorable court last 2 occasions. Earlier orders, my lord, I'll not point out. 2020.
If the undertaking affidavit is not filed by the next date of hearing, this petition will be decided on the merits of the
Akinta
matter.
munche, one more date. Before that also, my lord, same order.
I am requesting the honorable court that he has sent me this
13 for
affidavit.
sale.
Only the
The
thing
most
is he has
important
not sent. That's why
it's not
I'm.
way.
Let's this matter on 3rd of March. No further adjournment. At the request of Land Council for the petition. Why she has forgot this?
ರಿಸರ್ವ್ ಬುಕ್ ಅಲ್ಲಿ ಅದು ಚೇಂಬರ್ ಅಲ್ಲಿ ರಿಸರ್ವ್ ಬುಕ್ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟು ಬುಕ್ ಅಲ್ಲಿ ಸೈನ್ ಹಾಕ್ಸ್ಕೊಂಡು ಅದು ರಿಸರ್ವ್ ಮ್ಯಾಟರ್ ಕೊಟ್ಬಿಟ್ಟು ಸೈನ್ ಹಾಕ್ಸ್ಕೊಂಡ್ ಬನ್ನಿ.